I'm curious, and this is as much a question for Mr. Harris as it is for you, but I've lost my opportunity with him. What do you think Congress currently understands about Puerto Rico's immunity? Because usually clear statement rules operate against a backdrop of congressional understanding of what it needs to be clear about. And the clear statement rule of you have to be clear about abrogation. If Congress doesn't think Puerto Rico has immunity, why would it think that abrogation is even in the picture? So is there evidence about what Congress understands about sovereign immunity that would enable us to read this statute better?
I think the best and perhaps only evidence is the text of the Federal Relations Act, which actually recurs. There's similar language for some other territories, which is that there was some need to say that the generally applicable federal laws have the same force and effect in the states as they do in Puerto Rico, which suggests that Congress may have thought that there was some reason to think that, for instance, there should be a reciprocity if states have immunity, give that same statutory benefit to Puerto Rico. Again, that would sort of seem to suggest Congress understands that Puerto Rico would not have that immunity of its own force. I mean, I think the other indication is Congress seems to understand that the 11th Amendment is in fact just for states, because Congress, when it is doing the super clear types of abrogation that the other side seems to embrace, says that states shall not be immune under the 11th Amendment. It's not talking about territories. Now, that does create some oddities, I think, under their view, because I'm not sure if you had a clear statement rule for territories, like how that language would then abrogate for territories, which will create some sort of oddities for federal statutes. But that's all we have. And I think the fact that Congress does not seem to be operating on a baseline of sovereign immunity is reflective of this court's cases, which have never said that in federal court, Puerto Rico in fact enjoys this immunity. They are at best very muddy, and muddied yet further by the fact that federal courts were directly reviewing decisions of Puerto Rico courts and other territorial courts on territorial claims like well into the 20th century.
Justice Kagan?
Mr. Schnapper, can I give you 3 kinds of practices, and you tell me which gets 230 protection and which doesn't? So one is the YouTube practices that you're complaining of, and we know you think that that does not get 230 protection. A second would be Facebook or Twitter or any entity that essentially prioritizes items. So you're on Facebook and certain items are prioritized on your news feed, or certain tweets are prioritized on your Twitter feed, all right? And that there's some algorithm that's doing that and that's amplifying certain messages rather than other messages on your feed. That's the second. And then the third is just a regular search engine. You know, you put in a search and something comes back, and in some ways, you know, that's one giant recommendation system. Here's the first item you should look at. Here's the second item you should look at. So are all 3 of those not protected? Or what happens to my second and third? Are they protected or not protected? And if they are protected, what's the difference between them and your practices?
Certainly. So let me start with a search engine. There's a lot of discussion in search engines, but there's not a specific provision in the statute that says search engines are protected. The question is, do they fit within the language of the statute? So if I ask a search engine for stories about John Doe, and it gives me a list, and if I click on one of them, it turns out to be defamatory, they're not liable because they...
Well, they just gave it to you. It's the first thing. They've just prioritized it. They think it's really a great one to click on.
The mere there are multiple questions here. First, are they liable just because what you clicked on turned out to be defamatory? The answer we think is no. Secondly, what if the snippet that they took from the John Doe document said John Doe's a shoplifter? And the answer is they're not liable because they didn't write that. It's publishing third-party content. The third question is, could they be liable for the way they prioritize things? And the answer is, I think so. It's going to depend what happened. And the example,
So even all the way to the straight search engine, that they could be liable for their prioritization system.
Yes, there was a, let me,
Okay.
if I might continue,
I appreciate
No.
go ahead, I'm sorry.
those are the facts which led the European Union to fine Google 2.3 billion euros because they used prioritization to wipe out competition,
Okay, so
things
here's,
that were selling.
yeah, so I don't think that a court did it over there. And I think that that's my concern, is I can imagine a world where you're right that none of this stuff gets protection. And, you know, every other industry has to internalize the costs of its conduct. Why is it that the tech industry gets a pass? A little bit unclear. On the other hand, I mean, we're a court. We really don't know about these things. You know, these are not like the 9 greatest experts on the internet. And I don't have to accept all Ms. Blatt's "the sky is falling" stuff to accept something about, boy, there is a lot of uncertainty about going the way you would have us go, in part just because of the difficulty of drawing lines in this area, and just because of the fact that once we go with you, all of a sudden, we're finding that Google isn't protected. And maybe Congress should want that system. But isn't that something for Congress to do, not the court?
Well, I think the line drawing problems are real. No one minimizes that. I think that the task for this court is to apply the statute the way it was written. And if I might return to a point that Justice Alito made, much of what goes on now didn't exist in 1996. The statute was written to address 1 or 2 very specific problems about defamation cases. And it drew lines around certain kinds of things and protected those. It did not and could not have been written in such a way to protect everything else that might come along that was highly desirable. Congress didn't adopt a regulatory scheme. They protected a few things. It will inevitably happen, and has happened, that companies have devised practices which are maybe highly laudable, but they don't fit within the 4 walls of the statute. That will continue to happen no matter what you do. And the answer is when someone devises some new practice that may be highly desirable but doesn't fit within the 4 walls of the statute, the industry has to go back to Congress and say, we need you to broaden the statute because you wrote this to protect chat rooms in 1996, and we want to do something that doesn't fit within the statutes. And using thumbnails would be a perfect example of that.
Thank you. I mean, the conduct is the provision of a platform by which to communicate with each other and other members of ISIS, and by which to recruit. So you can, say it's the failure to better police the platform, but it's the provision of a platform.
The distinction that the cases make between action and inaction, and the plaintiffs in this case have repeatedly characterized the gravamen here as inaction, failure to do better to prevent more violations of an established policy. The distinction between...
Maybe that's right. I'm going to rewrite their complaint for them.
Okay.
It's the provision of a platform.
Okay. The distinction that all of the cases, the aiding and abetting cases, draw between action and inaction is culpability. And therefore, and what is alleged to be culpable in this case is not the provision to billions of users of a communications platform subject to established policies which are enforced. What's alleged to be culpable is that we knew from government reports and from newspaper reporting that there, notwithstanding whatever efforts we were making to enforce our policies, nonetheless, there were lots of terrorist organizations or terrorist adherents that were still doing it. That's the culpability, and that's why the restatement, for example, when it talks about, and I'm referring here to restatement 3rd, the substantially assisting a wrongdoer means affirmatively helping with the commission of the tort. It does not mean, it means, quote, something more than routine professional services.
I feel guilty that you're not
primary...
answering Justice Sotomayor's questions, but I'm just going to pile on a little bit, if you'll forgive me.
I think I have them in mind, and I will come back to them.
The same thing could have been said about banking. It was, we just provided the same banking services to the terrorists as we did to everybody else. But in fact, the provision of that service materially supported, and the bank knew that it was going to materially support terrorist operations.
So that may or may not be the case. The Second Circuit and the D.C. Circuit erred in, we think, notwithstanding the distinction that I'm having a hard time convincing you of, because they collapsed the mental state required under Step 2 and Step 3 of Halberstam. What they said is the pharmaceutical company was providing money and kickbacks to a known terrorist organization. It was generally aware that this was a terrorist organization. And that satisfies Step 3, which is the knowing provision of substantial assistance to an act of international terrorism. Likewise, the Second Circuit has said expressly that the only knowledge required to establish the requisite mental state for abetting a crime is general awareness of that you are aiding an enterprise. Now, the word enterprise, maybe I can shuffle back to or march back to Justice Sotomayor's question. You referred to the Halberstam's opinions discussion of the criminal enterprise and aiding and abetting the criminal enterprise. We are here, I have 3 points to make. One, we are here parsing the language of a statute. The word enterprise does not appear in the statute. The word that appears over and over and over again is the act of international terrorism that injured the plaintiff. Number two, the Congress in its findings said that it intended to import the legal framework set forth in a section of Halberstam conveniently called legal framework. Again, there is nothing in the legal framework set out there that talks about aiding and abetting or substantially assisting an enterprise. In any event, we don't in any way contest that the court, in applying the facts in Halberstam to the legal framework, referred over and over again to the substantial assistance that she was providing to the enterprise. Now, the word enterprise, if you look in the dictionary, has a variety of different meanings, but the two first meanings are, number one, it can refer to an entity that is typically a, quote, unit of economic organization, or quite distinctly, it can refer to an undertaking, systemic, purposeful activity. What Halberstam was using the term to do was to characterize a factual characterization of a series of property crimes in which it held that Bernard Welch and Linda Hamilton played, quote, symbiotic roles. It was not announcing a legal standard that encompasses a broad entity that provides general services to billions of people subject to an unequivocal enforced policy against terrorism. So even if I agree with you that you can establish substantial assistance to the principal tort by showing that there was a course of, a series of like acts of international terrorism or burglaries or property crimes in which the aider and abetter was, to quote the D.C. Circuit, a willing participant, and therefore aided and abetted the principal tort, which was the burglary of the Halberstam home. I don't have a problem with that.
Thank you, Mr. Waxman. Justice Thomas, anything further?
Well, that the last time we did this, every member of the D.C. Circuit.
We can go into this, but
So I'm just going to change the subject of
General, I'm sorry.
Justice Kagan, thank you.
Because there are
gonna
many,
go back.
many former members of the D.C. Circuit.
I'm going
I'd
back
like
to
to, okay. I'd like to hear about the merits of this case. I want to come back to some of the claims that both sets of respondents here have in common, dealing with what we've called the arbitrary and capricious aspects of the case. And as I understand it, the memorandum really talks about two things. It talks about forbearance, and it talks about sort of economic/COVID conditions. Forbearance as a kind of separate thing, that people who have been granted forbearance for long periods of time are more likely to go into default or become delinquent in their payments. And I guess I wonder, is that about COVID, or is that just about something that happens when you excuse loan payments for a long period of time, and how it is that that gets to be converted into an emergency COVID rationale? And then on the economic considerations, and I think it was Justice Barrett who talked about this a little, it seems, a real mixture of COVID and non-COVID related things. And of course, this is how the economy works, that COVID interacts with other features of the economy to produce certain economic conditions. But again, I'm wondering whether, there was more of an obligation on the part of the Secretary to isolate how COVID was affecting these borrowers.
Of course, and I'll take each of those considerations in turn. I'll start with your questions about forbearance, and I want to be really clear, because I think my friends have confused the issue about this a little bit, that the Secretary wasn't finding that forbearance itself had caused the economic harm to borrowers, or that it was the root cause of why they needed additional relief. Instead, the Secretary analyzed the historical data regarding forbearance as a data point in understanding that forbearance is not always a complete solution to the underlying economic harm caused by the national emergency. So here, there's no doubt that forbearance has provided very powerful and critical support to borrowers over the life of the COVID pandemic. But the Secretary found that once forbearance policy lifts, millions and millions of borrowers are going to be worse off with respect to their ability to pay because of COVID. The forbearance policy hasn't fixed the underlying economic harm of the pandemic and the emergency. So to the extent that there's a bootstrapping concern here, I just want to push back forcefully on that. I think that the Secretary's decision memorandum makes clear that sometimes additional relief is necessary, not because of forbearance, but in spite of forbearance. To turn to your question about the various causes or influences of economic harm here, it's of course true that I can't make a representation that the harms that borrowers are facing are solely due to COVID-19, but I think that it would be an impossible burden to place on the Secretary to suggest that he needs to isolate and identify just one economic factor or force that's causing that kind of distress for borrowers. Our economy is very complex, and there are often multiple factors and forces at play, but the Secretary here found, and I don't think that anyone could reasonably dispute, that but for COVID, borrowers would not be in this situation of facing severe financial harms and the very real risk that they'll have to go into default or delinquency when they start repaying their student loans. So I think to the extent that there's concern here about how the standard could operate, at the very least, the Secretary made the requisite findings that these are financial harms that derive directly from and are a but-for result of the COVID pandemic.
Isn't that your burden? I mean, I understood the government to say that you are bringing this lawsuit and you have to establish standing. And so to the extent we're trying to assess whether or not Mohila is actually going to be injured, I don't think you can answer, but the government hasn't said something about the fees.
Well, my point in bringing that up, Justice Jackson, is that the government hasn't said anything about the fees in responding to what we've already substantiated through the documents we've put in. We have put in documents indicating that this will amount to approximately a 40% loss of operating revenue for Mohila. And in response, the government referenced potential offsetting costs, which they don't quantify, and they don't show that that would significantly reduce the injury that we're anticipating.
Mohila isn't here, General Crawford. Is that correct?
Mohila is not here, but its interests are here.
It has the ability to sue and be sued. It's been set up as an independent corporate entity with the ability to bring suits on its own. Usually we don't allow one person to step into another's shoes and say, I think that person suffered a harm, even if the harm is very great. We leave it to the person, him or her or itself, to make that judgment. Now here, the state has derived very substantial benefits from setting up Mohila as an independent body with financial distance from the state and sue and be sued authority. So why isn't Mohila responsible for deciding whether to bring this suit?
We don't deny that Mohila could file a suit like that. But the state's interest is directly implicated here, so it is allowed to assert the interest it has in MOHELA directly.
But I guess, there are third parties all the time who have an interest in, gosh, I wish that party over there would bring a suit because I have some relationship with that third party, and I would like it very much if that third party represented its own interests better, in my view. But we don't do that. We don't allow that kind of interference with the decision of the entity involved to decide whether the harm is of the kind that they want to sue for.
Well, the government is different. This court has recognized that in cases like Cherry Cotton Mills and Erickson, where it's allowed the federal government to assert the interests of federally created corporations.
I believe that in those cases, the federal government had an independent interest. So the federal government was not saying, oh, we just have an entitlement to stand in the shoes of the federal corporation.
Two responses. The first response is I don't think that's the best reading, certainly, of Cherry Cotton Mills. Cherry Cotton Mills, the court discussed a number of facts, and then at the end said, the reason why the government can assert the federal corporation's interest is because it is performing purely governmental purposes. That's exactly what's happening here. The state of Missouri has declared that everything MOHELA does is the performance of an essential public function. So that's the first response. The second response is even if the state does need an interest, the state has an interest here. I'd identify at least three. The first interest is that the state created MOHELA to provide financial aid for Missouri students, and that's what it does. The second interest is in the Lewis and Clark Discovery Fund, and the third interest is in the regular contributions that MOHELA makes to the state scholarship programs. Now, there was some discussion earlier about the Lewis and Clark Fund and some suggestion that it's a dormant fund that no longer exists. I think it's clear, I think we need to clarify what exactly is the status. So yes, it's true that there hasn't been a contribution in the last 15 years, but that's because the state has negotiated with MOHELA for MOHELA, in lieu of making the Lewis and Clark contributions, to contribute over $65 million directly to the state scholarship program. And in exchange for those agreements, the state has allowed the Lewis and Clark deadline to be extended. So at this point, the question is, what's going to happen at the next deadline? The next deadline is coming up next year. And if the question before this court is whether cutting MOHELA's operating revenue by 40% will increase the risk that it either won't make the next contribution to the Lewis and Clark Fund or it won't make the next payment to the scholarship fund in lieu of the Lewis and Clark Fund.
It is correct, isn't it, that under your theory, subparagraph C5B is superfluous?
So, Justice Sotomayor, I think that's respectfully not quite the right way to look at it. I think anyone who was sentenced under Section C5B would have to be sentenced under Section C5A as well, and so you sort of have to take C5 as a whole. And of course, C5, because it's providing
But still, why add it? If how you kill somebody is irrelevant under your view, because they're all going to get the same sentence. So why did Congress add C5B?
I don't think there's a good explanation in the legislative history, Justice Sotomayor. I think my best guess is
That's because your reading doesn't treat them separately. You want us to mesh them together. That's the reason why. Petitioner's reading gives a reason. You're absolutely right. If you do it in this way, you're going to get this minimum. If you don't do it in this way, you get the maximum under J alone.
So if I'm understanding the question correctly, Justice Sotomayor, I think the difference petitioner posits between C5B and J is, everybody agrees that C5B has its own mandatory minimums, or excuse me, C5A has its own mandatory minimum. So then he says the work
I'm
that
talking about C5B.
Right, and he says that the work that C5B is doing is that it is requiring a consecutive sentence, whereas under J, that's optional. And respectfully, I just think there's no indication that Congress was seeking to distinguish between these provisions in that way. I think the far better reading is probably that Congress was just trying to be complete and make sure that there was no confusion, that the same penalties that apply in J would still apply if you killed someone through the use of the armor-piercing ammunition.
Isn't the truth of the matter here that Congress just made a mistake?
Your Honor, if you thought that Congress just made a mistake, particularly, we haven't really discussed the Blockberger question. I do want to get there. But if you thought that Congress made a mistake such that, the right result from the language was that this is all one offense, we have to charge J or C, but when we charge J, when we recognize what Congress recognized as a far more serious offense, then we lose the mandatory minimum consecutive penalty in C. I think that might be a case for an absurdity type of construction because it is so implausible. But of course, we don't think you need to get there because we think the text and the structure and the history of the statute are themselves sufficient to clarify whatever ambiguity there is here.
Why is it absurd? You have a sentence that gives you permission to impose the death penalty. That's a really big difference. We rule under absurdity where it makes no sense whatsoever. The whole purpose of J was to give the prosecutor even more of a weapon, death.
So a couple of points on that, Your Honor. I think obviously that is a purpose of J, but I think as I was noting, there are inevitably going to be term of years sentences under J, and in that instance, I think it is quite implausible. You don't even need to get to absurdity. I'd point to this court's decision in Abbott where it rejected implausible, bizarre results under 924C. It's quite implausible that Congress intended when you actually take the gun out and kill someone with it for a lesser sentence to be possible than when it's simply in the defendant's pocket. On that,
Keep going, I'm sorry.
On that, I just wanted to point out, my friend was talking about it makes sense to have discretion perhaps in the involuntary manslaughter context. A few points on that. One is that I think involuntary manslaughter here is really the tail wagging the dog. If you look at pages 9 to 10 of petitioner's reply brief where he's talking about this, most of his examples are involuntary manslaughter. And then on page 23, he's talking about, the physician who is going to prescribe suicide-inducing drugs, and he brings his gun because he's concerned that the family is going to violently intervene, and then the gun goes off and it kills the elderly patient. I think that's so unlikely that should not sort of drive the train here. And I think it's also true that even that doesn't make sense because Congress, of course, didn't want discretion when no manslaughter occurred. And so it doesn't make any sense to say you need it.
I wonder whether there isn't a broader principle at stake in a case like Haven's. I mean, here your client has disclaimed, has said, I'm not intending to go on vacation at all. I'm not intending to go to any hotel. I'm not intending to use the reservation service at all to look for accessible hotels, to reserve at accessible hotels, to go to accessible hotels. I'm not doing any of that. So tell me how she is discriminated against by the inaccuracies on this website.
The reason that the case comes to the court in that posture is because injunctive relief is so elusive when you're talking about concrete travel plans. It was noted earlier, Ms. Laufer did amend her complaint in this case to say that she was going on this long road trip. But when the case was on appeal, she had already gone on the road trip. And so that's why when we say she's disclaimed any intent of going on a trip, it's because by the time the case was on appeal, she had already gone on the trip.
Well, that's the case that's before us. It's a case that before us with a stipulation that she's not using the website for any vacation purposes. That she's, and I think that your brief reads like this too, that the harm is, well, I'm not sure. You tell me. The harm is just, I'm a person with a disability and I see that there is inaccurate information about accessibility, and that itself harms me even if I have no plans or less than plans. I'm just not thinking about vacations at all.
Yeah, so I'll start by saying that the reason all of these tester cases, or really any of these reservation rule cases, are going to be in that posture is because you can't have concrete or even somewhat concrete travel plans and get an injunction in time. So that's why these cases have been just generally litigated in this way, in this pure tester posture. But the injury here, again, it's not just a denial of information. The day-to-day experience of being a disabled person is to have your world be very small because our marketplace, our places of public accommodation just ignore you. They don't see you. They don't recognize you as a potential customer or as a member of the marketplace. And so when Ms. Laufer goes to the website and she sees that she's invisible, that they are not even acknowledging
Well,
her.
suppose she goes to the website and rather than look at accessibility information, she goes to the website and she looks at lots of pictures of places and says, oh, this one doesn't have the required ramps. And again, she's not going to those places. She has no intent of going to those places, but she sees that they don't have the required ramps, and she brings suit then. Does she have standing to do that? Because I think that that's pretty similar to what is going on in this case.
So she does not have standing based on the pictures because she's not encountering the accessibility barrier herself.
Well, I
She's
don't
just
know. It's
seeing-
like right there. I mean, if you're saying it's how you experience discrimination, and I can understand that, but I'm experiencing that sense of being excluded when I see that all these hotels are set up to exclude me and others like me.
There might be some sort of Article 3 argument there, but Congress certainly hasn't provided a cause of action there unless you actually have plans to go to the hotel. And I want to go back, I think, Justice.
Go back to your answer to Justice Thomas. The purpose of summary judgment is to decide the ultimate question: who owns the car, correct?
Yes.
The purpose of a post-seizure hearing is to determine who keeps custody of the car, correct?
Yes.
And the focus is therefore different. The focus in the in the hearing would be: there might be a disputed issue of fact with respect to ownership. The government might claim it needs discovery. A government might claim it has some facts that would lead to a judgment that it needs to explore. But the court would then weigh whether or not that is sufficient not to give custody to the car owner pending the hearing, correct?
Yes, Justice Sotomayor.
So summary judgment doesn't answer this question or the isolated question of who keeps custody of the car pending the ultimate judgment, correct?
That's right.
May I ask about
that?
I'm sorry, please.
No, I was just going to say whether or not summary judgment is adequate, given that difference in the focus of the hearings. I'm presuming that's why you're saying that's not the issue before us. The issue before us is what of the two tests do we apply to determine whether that's enough or not, correct?
That's right, Justice.
I mean, if I could ask about that same kind of thing, what the difference is between the retention hearing and the final forfeiture determination. I mean, take a case like this where your client is raising an innocent owner defense. Now, I would think that the questions about whether she was an innocent owner are pretty much the same in the retention hearing and in the final forfeiture determination. Isn't that correct?
I think the substantive question is the same, yes.
Now, there is a different burden, but if she can prove at the retention hearing under a probable cause standard that she is entitled to the car back, I mean, there's no way the government is going to lose on the final determination, right? I mean, she's proved that she's entitled to the car.
I think that's most likely correct. In theory, by the time of the final determination, there could be some additional discovery or investigation that happens that would change the calculus.
Yeah,
but
I
most
suppose
likely,
in an individual case, but most likely the government probably would just give up at that point, right? Under this, very generous standard to the government they've lost. They're not going to keep on pursuing the thing. So she's gotten her car back and the case is over. And I guess what this suggests is that in both cases you're really adjudicating the same thing, which is, like, am I entitled to my car back right now? So how is it really different? I understand saying this is interim, this is final, but in the end it's just, am I entitled to my car back now?
Justice Kagan, I think that the substantive question is the same, but there are a few key differences between the retention hearing and the later merits determination. For one thing, I don't know that the premise is correct that the government would just give up if it loses at the retention hearing. Again, there's a different procedural standard later. The government has the opportunity to conduct more discovery. The government also has in Alabama, as well as 25 other states, a financial incentive to keep pursuing the forfeiture proceedings because they get to keep the proceeds. And so I don't know that it's empirically correct that the government would simply give up if it loses at the retention hearing. In addition to that,
I guess what I'm asking is if we've had a case that says, you know, the constitutional rule about forcing a determination about who's entitled to the car is the Barker rule. You know, why it is that we can say, well, we have that rule, but in fact, there's another constitutional rule which is much more beneficial to the claimant that's meant to address exactly the same question that we held in 8850 was addressed by Parker.
So I think they're different. For one thing, I think they are different questions, as the Second and the Sixth Circuit have explained. In Barker, the only question, it was essentially a case where the claimant was trying to argue a gotcha. There was no argument in 8850 or von Neumann that the government was not ultimately entitled to forfeit the property. There was no innocent owner defense. The claimant's argument there was, well, but you waited too long in order to actually complete the proceedings, and therefore I get my car back. And in that situation, this court said the Barker test applies. There's a different argument where you have an innocent owner defense, where you have somebody coming forward and saying, I should be entitled, as a matter of Alabama state law, the rights that Alabama state law gives to me, I should be entitled to keep my car. And the state can't effect a de facto forfeiture of that car for months or years during the pendency of proceedings.
This is what I think. This is where you want to talk to me. That, under this court's decision in Lane, is what any government official can do in their personal capacity.
So that means President Trump's Twitter account was also personal?
Yeah, I think that was a harder question, Your Honor, because there was, in that case, use of a government staffer to help him run the page.
Suppose that there wasn't. Suppose that, you know, he gave every indication of writing his tweets himself, and suppose he had also posted them, so there wasn't a staffer involved.
Yes, Your Honor. Then I think that he is engaging in his First Amendment rights under this court's decision in Lane to talk about the government in his individual capacity.
But he seemed to be doing you know, a lot of government on his Twitter account. I mean, sometimes he was announcing policies, even when he wasn't. I mean, I don't think a citizen would be able to really understand the Trump presidency, if you will, without any access to all the things that the president said on that account. It was an important part of how he wielded his authority. And to cut a citizen off from that is to cut a citizen off from part of the way that government works.
So a couple of things about that, Your Honor. The first is President Trump could have done exactly the same thing from Mar-a-Lago or a campaign rally. If he gave every one of those speeches at his personal residence, it wouldn't somehow convert his residence into government property. And in terms of people being cut off from it, people don't have a right to access other people's personal property. The blocking here doesn't turn on...
It seems a little bit, you know, to focus on the wrong end of the stick, if you will. I mean, the fact that it was his personal property seems neither here nor there. If really he was doing government on it and wielding his authority on it and announcing policy on it, and you know, it was part of the way government operated.
Well, so here's why I don't think that's quite right, Your Honor. Imagine he had put on his page a clear disclaimer. This is my page that I'm using in my personal capacity to talk about the government. This is not an official page. Every single word on that Twitter account could have been the same.
Right, but why shouldn't we require that then, if you're right? In other words, it seems to me the problem that we're having is, even if we agree with you that government officials can operate in their personal capacity and in their official capacity, why should they get to choose whether or not they're doing one or the other without, say, making a clear disclaimer or making it clear to people that this is actually happening in their personal capacity?
So I'll give you two reasons, one conceptual and one practical. The conceptual reason is because the First Amendment generally doesn't compel speech. It generally protects against compelled speech.
Yeah, but you can't have it both ways. I mean, to the extent that we know and we agree with you that the person can operate in one or the other, I don't understand why it would necessarily be a compulsion to have them do so clearly.
So because what is basically being said is if everyone agrees my clients could have said this in their individual capacity and had First Amendment rights to do so, but they will lose those rights unless they put up a disclaimer, that is basically saying...
No, I'm not saying they'll lose the right? You can go down road A or road B. You have the freedom to do that. The question in this case is how do we know which you have chosen?
Right, and so the disclaimer is essentially a condition that is being required to go down row A rather than row B. That is an odd thing to say that the First Amendment of its own force compels. Let me also give you a practical reason why this is the right way to think about it. You're setting up a trap for the unwary. There are lots of government officials in this country. They're probably not all going to read this court's decision. And if you adopt a rule that the only way they can exercise their rights under Halleck to exclude people from their personal property is to include a disclaimer, some of those people aren't going to do it, and they're going to lose their First Amendment rights. And that's the exact opposite of how the First Amendment normally works. This court normally adopts presumptions and rules that protect the First Amendment. That's set up prophylactic boundaries to ensure that you don't inadvertently lose your rights.
Well, this is a case where there are First Amendment interests on both sides. I mean, just as there may be First Amendment interests in protecting the private speech of government employees, there are also First Amendment interests in enabling citizens to access the important parts of their government.
Right, but
that's what makes these cases hard, is that there are First Amendment interests all over the place.
Well, but the difficulty is, as Justice Jackson said, it is entirely in my client's control whether these pages are used in their individual capacity or their official capacity. So whatever First Amendment interest is on the other side is extraordinarily weak, because all we have to do is put up a disclaimer and their right completely evaporates. So on the one hand, you'd be adopting a rule that every government official in this country runs the risk of inadvertently losing control over their property because they didn't put up a disclaimer. On the other hand, you have a disclaimer, their clients are still blocked, and everything else happens exactly the same.
Thank you, counsel. Justice Sotomayor? Justice Kagan?
General, there seems to be a fair bit of division and a fair bit of confusion about what Bruin means and what Bruin requires in the lower courts. And I'm wondering if you think that there's any useful guidance, in addition to resolving this case, but any useful guidance we can give to lower courts about the methodology that Bruin requires be used and how that applies to cases even outside of this one.
Yes, I think that there are three fundamental errors in methodology that this case exemplifies and that we are seeing repeated in other lower courts, and that this case provides an opportunity for the court to clarify that Bruin should not be interpreted in the way that respondent is suggesting. The first error we see is that respondent has asserted here, and other courts have embraced the idea that the only thing that matters under Bruin is regulation. In other words, you can't look at all of the other sources of history that usually bear on original meaning. And I don't think that that can be squared with this court's precedent, starting with Heller, which consulted a wide variety of historical sources, the same kind of evidence we've come forward with here about English practice, state constitutional precursors, treatises, commentaries, state judicial decisions. All of that is relevant evidence about the scope of the Second Amendment right, and I think the court could make clear that it's not a regulation-only test. Second, I think that looking just at regulations themselves, one of the fundamental problems with how courts are applying Bruin is the level of generality at which they're parsing the historical evidence. Court after court has looked at the government's examples and picked them apart to say, well, taking them one by one, there's a minute difference between how this regulation operated in 1791 or the ensuing decades and how Section 922 provisions operate today. And I think that comes very close to requiring us to have a dead ringer when Bruin itself said that's not necessary. The way constitutional interpretation usually proceeds is to use history and regulation to identify principles, the enduring principles that define the scope of the Second Amendment right. And so we think that you should make clear that courts should come up a level of generality and not nitpick the historical analogs that we're offering to that degree. And third and finally, I think that in many instances, courts are placing dispositive weight on the absence of regulation in a circumstance where there's no reason to think that that was due to constitutional concerns. So for example, here we don't have a regulation disarming domestic abusers, but there is nothing on the other side of the interpretive question in this case to suggest that anyone thought you couldn't disarm domestic abusers or couldn't disarm dangerous people. And in that kind of context, I think to suggest that the absence of regulation bears substantially on the meaning of the Second Amendment is to take a wrong turn. It's contrary to the situation the court confronted in Bruin, where there was a lot of historical evidence to say states can't completely prohibit public carry. And against that evidence, you might say that the absence of regulation is significant. But here, there's nothing on the other side of this interpretive question, and I think that that just shows that you shouldn't hold the absence of a direct regulation against us.
Thank you.